Welcome to the best part of the day, except for all the other parts of the day that are pretty good too. I'm Frank Bruno. I'm an estate planning and elder law attorney in New York. Today is part 2 in my series on estate planning basics. Yesterday I covered the laws of intestacy, and today I'm moving on to joint tenancy, joint ownership of property. So if we take estate planning as a continuum, from doing the least to doing the most, doing the least is doing nothing and allowing your estate to be transferred by the laws of intestacy. And if you die without a will, it's intestate, and it could be a good plan if you have maybe small assets and low assets and a small family. So all the way to the most complicated, which would be a trust and a complicated scheme or plan for succession planning, right? So I'm still at the early stages here, and I'm going to be speaking about joint tenancy. So a fine plan that can be used is that you can own property with someone else, right? So you can own real property, a house, an apartment building, a multiple dwelling, any kind of real property. You can own it with another person as a joint owner. And upon either person predeceasing the other, the last to stand, the last to remain surviving, winner takes all, that joint holder will own the property alone. This, in New York, it will frustrate a will. The deed will govern the property before any will. So if I own property with my wife jointly, and in my will, I put that I want that piece of property, my portion of it, to go to a charity or a friend or whoever, the will come second. The deed will take effect by operation of law upon my death. So you really need to own the property, own a property with someone that you would like to have the property upon your death. So it's very good for people in certain circumstances, right? A husband and wife, a parent and a child in some instances, perhaps siblings that are young adults, but young, maybe in their 20s, that don't have spouses or children. It might make sense in that instance. But if you have children, if you have a blended family, the joint tenancy may not be a good option for you. Now, many people also have bank accounts jointly owned. So a jointly owned bank account, that permits either person to make all deposits, and you want everyone, right, to be able to deposit into your account, but it also allows the two joint holders to equally withdraw any money. So if there's $10 in a bank account, either person can take out all $10, right? Now, if you want to, sometimes there's a primary and a secondary. Say I had a bank account and I wanted to add a spouse or a child onto my account as a joint holder. If I had opened it up first and then added a person as a joint, they could be classified as a secondary. A bank typically will allow me to remove a secondary person. But if the account was opened together, and this is subject to what your bank is willing to do. If you open up an account with another person and you want to close it, or you want to remove the other person, right? Either person goes into the bank and says, I want to remove my joint holder. Well, the bank will require that both persons are present at the bank at once. An alternate strategy would be, because even though you can't close the bank account without both people being present, either person could remove 100% of the value of the account, and then just open up a new account. So you have to be very careful who you have as the joint holder in a bank account, right? It needs to be someone that you trust and someone that you don't mind taking all of the funds from you. So if you have any questions, if you'd like to speak to me about this, please go to callfrankbruno.com. Thank you.